hail to the pumpkin song. In this town, don't we love it now? Everybody's waiting for the next surprise. Skeleton Jack might catch you in the back and scream like a banshee, make you jump out of your skin. This is Halloween, everybody scream. Please make way for a very special time. Our man Jack is king of the pumpkin patch. Everyone hail to the pumpkin king now. This is Halloween, this is Halloween, 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 Halloween. That's our job, but we're not mean. In our town of Halloween. In this town we call home. Everyone hail to the pumpkin song.
Hey, everybody. Party will be right back. Well, thank you, Lizzie from Aussie, from the $30.99 Australian. And Natalie will be joining us as well. I'll already put this stuff.
Hello. I'm here. Sorry about that. I had to do it. Be real quick. We should be having Natalie in soon. But for now, we're catching the last bits of testimony that's live right now.
Overruled. I'm sorry, what was the name?
Elliot.
Thank
Elliot
you.
Hallmark.
When you saw the vehicle and as it was coming towards you, could you estimate the speed that the vehicle was traveling?
Objection, hearsay.
Overruled. You may answer.
I estimated the vehicle traveling about 30 to 40 miles an hour.
What is the speed limit in that area of Main Street?
25 miles per hour.
So you threw your 3-year-old to your left, you stated?
Towards the curb, which would have been to the south.
And how about Elliot?
I don't remember at that point what happened with Elliot. As the vehicle passed us, I don't know if he got ripped out of my arms when the vehicle came through. I just remember that I kind of got, as I turned to my left, I pivoted on my left foot. I got clipped to my left foot, and the vehicle passed us, but I don't recall what happened with Elliot.
How about Ben?
Ben, I saw him stumble and kind of roll from where the vehicle came towards the curb to the south.
Now, when you said you got clipped, what clipped you?
Objection.
Overruled.
It had to have been the vehicle. I had an abrasion on my left heel, and then I just white sneakers on that night, and they had black marks along where I had my abrasion on that same part.
What was that consistent with, those black marks?
I would guess the vehicle tire.
Where was your wife?
She was standing a little bit behind and then to the left of us, so she would have been a little further at that point, a little bit further to the east and then to the south.
Now, in terms of the path that the vehicle was traveling prior to it striking your group, can you describe that for the jury in terms of, was it on the north side of the road or the south side? Or, to explain it to someone like me, if you're traveling down the parade route, was it on your left or on your right?
Objection, leading the witness.
Overruled.
As it was coming towards us, as I was walking initially, we were kind of in the center of the road. So when I saw the vehicle coming, I kind of moved to the left and threw my kids to the left. So we were kind of left of the center line, so to the left, as you described, and towards the south. But the vehicle had passed me on my right.
And did you say that you observed anyone get hit that was behind you?
I don't
leading the witness.
Overruled.
I don't recall seeing anyone specifically getting hit. I do remember hearing sounds of the vehicle striking objects, and the only objects in the road were people at the time.
What happened next, or what do you remember next?
I remember turning to my wife and asking her if all the children were okay, and she looked back at me and said that she didn't know where our son Elliot was. And at that point, I couldn't see him either, so I began running up and down Main Street trying to locate where he was.
Did you have eyes on your 3 other children?
I did.
And what did you do with those 3 kids?
I had those children stay with my wife while I went and tried to find Elliot.
Did you find Elliot?
It was some time after, I would estimate it to be
We're working on getting Natalie in the Discord.
a minute to 2 minutes after the vehicle had passed, but I had located him on the road further to the south, almost immediately to where the curb was, being tended to by some individuals that had covered him up with a blanket.
While you were looking for Elliot, did you see anyone else on the ground?
I did.
Can you describe for the jury what you observed?
There was a lot of individuals laying on the road as you look back, and I remember specifically seeing Father Pat Heppy laying on the ground. I remember he was, at that point when I had saw him, I thought he was deceased because he wasn't moving at all, so I would assume that he was knocked unconscious. I continued past, and then I remember specifically seeing a younger female who I recall to be as Yamilet Perales laying in the roadway. And 2, I thought she was also deceased because there was blood coming from like her ears, and she wasn't moving either.
Did you see anyone else before you found your son Elliot?
There was other people, but I don't specifically recalling at that particular time, no.
Once you found Elliot, what observations did you make of him?
At this point, he was awake. The person that was tending to him indicated that he was knocked unconscious. So when I had found him, he actually
Welcome everybody
consciousness, but he
who
was
is bumping in.
and complaining of
Good to see y'all.
injuries to his back and to his hip and to his leg.
What did you do then?
Pretty much just, I was told by the individuals that were caring for him that that we needed to keep him there for safety purposes, for like C-spine, making sure they didn't have any significant neck injuries or back injuries, and that we needed to wait there until paramedics arrived.
They eventually come and assess Elliot?
Yes, during this time I had spoken with my wife, and the decision was made that she was going to go get the car because it was, at this point, it was chaos in downtown Waukesha, and I'd actually made contact with a couple of different officers that I knew from the police department, and one of the comments was we didn't know how we were going to get a lot of these injured folks from the street to the hospital that needed care. So a decision was made that I was going to send my wife to go get the vehicle so she can remove our 3 kids that were mobile and remove them from the scene. At that time, I didn't know the extent of the injuries to Benjamin.
Okay. And that's what I was just going to ask you about. Were there any observable injuries to Benjamin at the time immediately following the car going through the group?
Objection, leading the witness.
Overruled. You may answer.
I knew that he had been injured because when I had looked over to where he was over on the curb, I had seen that he had some facial injuries, swollen eyes, some lacerations. But he was calm and he was collected. So at that point,
Hey, Nat.
I didn't know that there was any other injuries to him. After the paramedics had put Elliot
You're muted,
on,
honey.
Yeah, you're currently
structure,
muted.
I indicated that Benjamin was hurt and I needed to go bring him with us when we went to the
Or
hospital.
on maybe push to talk.
After I went over to him to pick him up, I had looked down and I had realized that he had an open fracture to his left leg.
So what did you do?
I picked him up and then we
Try to change
ran
it
with the
for.
paramedics down to, they called it the casualty collection point, or the point where all the ambulances were caring for individual folks.
And did you ride in the ambulance with Elliot and Ben, or did they go separately?
We went together.
Okay. Where did you go?
I went to Waukesha Memorial Hospital.
And what happened once you were at Waukesha Memorial Hospital? What did you see in general?
Yeah, I mean, as working in the city, we go to Waukesha Memorial Hospital quite a bit, and I have never seen anything like this in my entire life. It was pretty much chaos. When we first got to the hospital, there was some sort of physician or EMT that was actually triaging individuals.
Hey.
With, I believe it was permanent marker, and they were triaging individuals on their forehead of what level of injury they needed.
I see you, Nat.
It's kind of directed word to they had gone inside the hospital. So when we had gone into the hospital, we were directed into the waiting room. And at that point, we were still on kind of like stretchers or backboards. We were placed in the waiting room, and we were just waiting until we could be attended to by some of the staff.
And did both Benjamin and Elliot receive treatment at Waukesha Memorial Hospital?
Yes.
What treatment did they receive, if you know?
Elliot received treatment for a severe concussion. He had a severe ankle sprain. They did a CT scan. And then with Benjamin, he ended up spending the night because the same thing, concussion. They did a CT scan, but then he also had surgery on his broken leg that night.
Now you stated initially when the car was coming towards the back of
Nat,
the group.
just to confirm, can you see us and hear us?
Just accidentally got in the Christmas parade route, correct?
I don't think you can hear me.
Yep.
I can hear you.
Not the question.
It's working.
Or answer, rather.
Asked and answered, sustained.
So after having your initial thought, did your thought change at some point that this isn't a misguided vehicle?
Yes.
And what did it change to?
Objection, leading the witness.
Overruled.
After the vehicle had come through and struck our group, and then as I looked back at all the carnage behind us, it was pretty, my thought then that we were involved in some sort of terrorist act. It was.
As much as I want to listen to the rest of this, I know, Nat, you have another engagement at 7:30. So I want to go directly to the kind of the moments that we all know kind of what happened today.
Okay.
So I'm gonna get that video out. Ready for us here.
Okay.
So at the time I emailed you, Dale Brooks decided to go. I mean, if he wasn't already over the deep end, he gone full blown sovereign citizen.
I'm not gonna lie, I'm genuinely surprised.
I know. You were saying earlier that he was going to mitigate, but I said that I could easily see him going even further beyond the other side, and he clearly chose the latter.
Brooks, why? I was rooting for you to at least have a fair trial and not to sabotage yourself.
All right, so let me change this. And here, make sure you click up if you got. Can you guys see my screen or see what I'm sharing?
I can see what you're sharing. Yes, it's like in the
Okay.
corner of it. I don't. Where are the comments? I can't tell what's going on. This looks so different than YouTube.
Are you using the application? Or
No, I'm on the
or
website.
is it the web browser? The web. Well, the chat is through YouTube. It's still through YouTube.
Oh,
Yeah.
Wow. Okay. I was trying to let people know I was here. Okay, here I am. Awesome. Great.
All right, perfect. And all right, now the next thing is I want to make sure that you guys can hear the video.
Consent to being called by the name that this court chooses to identify me by. I want to state for
Mandy,
the
can you
record
hear it?
that I'm here as a third-party
All right,
intervener
perfect.
on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury out.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right,
power?
Can you please take the jury out? Thank you.
I'm gonna
Mr. Brooks, just wait till the jury's out, please.
I'm gonna promise
I asked you to
the chat that we're not gonna go
Thank you.
through all of it because he ends up circling back and kind of repeating himself. She lets him go on for almost 50 minutes.
5-0 or 1-5?
5-0.
Oh, but let's watch some though.
No, we are, but I'm not going to subject to the entirety because he repeats himself. He starts repeating himself.
Everyone else can be, you all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify.
She took the jury back out.
Do I consent to being called that name? Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
Oh my God.
Yeah.
I understand what you're asking me, sir.
I'm asking, is
And on what legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What
Admiralty Maritime
what are
Jurisdiction
we
drink.
in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy.
Yes, Jake. This is in the middle, in between witnesses. This is basically in the middle of it, before lunch.
I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and
The right to a speedy trial.
that is
your right
based
to
on
a
the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested
It's
for
not
the
a civil
complaint
claim.
to be provided. The complaint from November 23 of 2021. The amended complaint from November 21.
I know, right? Like, companies sue each other all the time, so I don't even know what he's getting at there.
12 of this year,
Right, and
2022.
governments bring
I have
things
yet
in.
to see those.
So that's ridiculous.
There was no record of a bond in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases
Everybody's
clear
got their
biases
kitties except for me.
and questions that are not being
I have
asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've
Subject
raised
matter
that issue
jurisdiction again.
numerous times, pretty much every day, every time I come before your court, Your Honor. I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges.
Nature and cause, drink.
Proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted.
What? We're gonna 12B6 a criminal case.
Everything that I'm saying
failure to appear apparently
has merit and it has validity. As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record.
Yeah, he's questioning whether they're just members of the private bar association or whether they're actually licensed attorneys.
Not the private bar.
Yeah.
Anyway.
Yeah.
I'm not even sure if that was even recorded in the docket sheet.
All right, hold on, guys.
There's so many things. And Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven.
Military power is full power of the state, by the way.
Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over.
Oh, yeah.
No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by inmate communication. Nothing gets certified that I get copies of when I clearly asked for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people.
I'm waiting for a particular moment.
That's not being done here.
And then I'm going to fast forward.
Every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided.
What?
Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair, which is
Mr.
another
Brooks,
right that I have, the
Dennis,
right to a fair
stop
trial
this.
and the right to an impartial jury. I could go on and on and on about what's not.
You do go on and on and on. She let you go on for 50 minutes.
I say I have the right to face my accuser. Where's the injured party? Who's making the
Every
claim?
single fucking
I
time.
asked Your Honor.
Every single fucking time he says, "Where's the injured party?" or what, "There's no proof of an injured party."
Everyone in this case has been an injured party.
Every single time he says that, I have to control myself because
Numerous times for Your Honor's name.
And, sorry,
You wouldn't
and the
answer.
ultimate injured party can't testify because they're dead.
right.
So
That's what I was saying. That's what I keep on saying to every single time I hear a sovereign citizen try to make this claim. There's no injured party, therefore there's no crime, or there's no injured party that faced my accuser or something. And I ask him, what happens in the fucking murder case?
here we go.
And they'll say, oh well, they're the estate or something. The estate will bring the claim. What if he's fucking homeless and has no immediate family? What if it's somebody random nobody cares about? Is it not that you can get away with it? That's why this entire ideology is completely fucked. They don't understand it, and yeah, it goes to show you how this script, this whole ideology, is built around what they perceive to be as victimless crimes. It's never going to be built around where there is actual people who are hurt or actually damaged.
I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything, which you stated for the record a non-responsive answer. A non-responsive answer is an agreement, which would be a tactic agreement by you, Your Honor, that
Stop
you don't
saying
have to
tack
answer
it.
these questions that you should be
We
answering.
pass it.
Yeah.
I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom?
Fucking hell.
The question is shut down, which is a valid question.
No,
The
it's
plaintiff
not.
should be present
Oh,
in this matter. Where is the plaintiff? Who's bringing the claim?
This is not a civil case.
Because we know it.
Even if it's not a civil case, an entity can bring an action. It's the people of the state of Wisconsin, the attorneys, the state prosecutors. They are acting on behalf of the people of the state of Wisconsin. That again, I don't even know why I bothered to even.
Totally maddening. This will make you crazy watching. It's just so counterfactual. It's insulting. It makes absolutely no sense. And deep down inside, he has to know that. Like, he has to know that this is bullshit.
This is because it's not as if this is his first rodeo with the justice system.
Right. He's been to court before. He's been convicted of multiple crimes. He knows what it means to go through the criminal justice system. So somewhere in there, he knows this is bullshit. This is not your strategy to get out of this case. This is not going to work. And all you're doing is making a fool of yourself on the way to prison.
Right.
Entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place in the evidence any unrevealed contract. Has that been provided to me? Have that been placed into evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told,
Thank you, Robbie Anderson, for the
to shut the
$9.99.
question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide.
They don't decide issues of law.
The matter.
Even if his argument
Why are
was
we
valid.
keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times.
I really would love to know if they could find out which jailhouse lawyer fed him this.
That may have been suggested on behalf of my former attorneys.
He's gonna
I've
be the
never
jailhouse
even
lawyer. Probably
will.
to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution.
That's a classic one.
We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea.
They don't have to.
They don't have to.
That's another issue.
Prosecution does not have to offer a plea.
I have the right to challenge the jurisdiction of this court, which I've done numerous times.
Done that, and you've lost.
And you've lost repeatedly. You don't like the fact that you've lost.
I have the right to demand that the code be construed in harmony with the common law. I just raised that.
Common law.
I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney.
No shit.
In fact, the court is also aware that I only had 3 days to prepare for a trial.
Bullshit. And yeah,
his choice.
He was warned several times at the Ferretta, at the motion hearing for the attorneys to withdraw. I am not going to move this trial. If you decide to go your own way, I am not moving this trial. You are fine with it. So do not come back and bitch about not having enough time to prepare.
That the prosecution has been prepared for a whole year.
That's your fault.
We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it.
You assumed that risk.
It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September.
You already litigated
which trial
this.
was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork?
Sounds like a personal problem.
She told you not to represent yourself because you wouldn't have time to prepare. She told you that. And that's already been litigated when he tried to get a continuance for having fake COVID or, pretending to have COVID. He tried to raise this and she said that's not a reason. And he even conceded that's not a reason because he got the stuff in his cell. And she told him when he waived his right to an attorney that he had only 3 days to prepare for a 6-time murder trial. She told him that. He said he didn't care. He wanted to represent himself. Look at the consequences of your actions, sir.
Yeah.
All the digital discovery and things of that nature. How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare.
What, clear bias? What, to let you represent yourself that you wanted so badly?
For this. Everything I'm doing is off the top of my head, winging it, taking it as it comes.
No shit.
The court is well aware that I was not prepared. I raised the issue that it should be an adjournment, at least at the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude.
Then maybe you should have stuck with your attorneys.
That's clear bias.
That's not bias.
I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment.
Article 3? What the no.
I raised that issue again.
I said this multiple times. The 6th Amendment says that the accused shall have the right to confront the witnesses against them. It doesn't say anything about being able to face your accuser. Witnesses against them, which you've been doing for the last several days. The entire week.
Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor?
Every time he does this, I want to throttle him because there are injured
parties here. Do you know of anyone that can make a claim against me, Your Honor?
Injured parties galore.
Can anyone right now in court, anyone, make a claim against me?
Oh my God. Oh my God.
And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim?
Sir, respectfully, go to hell.
I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down.
I know.
Hey, Big Smoke.
Under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally.
Lies.
Okay, so he's starting to repeat him. So he's starting to repeat himself. But I want people in the chat. If anybody who's seen this clip that I got, it's from the what's it called? The TCMJ or whatever the heck, the local channel. They clipped his entire rant and the responses by them. There's at one point throughout this entire bullshit that he actually either directly accuses or implies that the judge is committing treason. I can't.
He means no disrespect, though, Artie.
Yeah, but I don't know. But he's already starting to repeat himself. I'm trying to figure out at what point throughout this rant does he actually say that explicitly treason.
I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity.
Thank you, Taco. WTMJ or...
I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly
WTMJ, that's what it is. Yeah, I could put it at 2x speed.
Without a lawful explanation. I've repeatedly asked the court for finding a fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right.
Yeah, shout out to this judge's patience.
I have the right to recuse the judge at any time, which is also a right.
Recuse the judge?
I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge.
All right, real briefly, Natalie, when does the right to speedy trial start to become an issue? Like, how long between the crime or the charges filed and the trial itself?
There's two different speedy trial analyses. There is the constitutional speedy trial analysis that's applied to every case, no matter what state you're in. Then every state has their own statutory speedy trial analysis where they'll put like a year's limit on it.
Right.
So I'm not sure if Minnesota has one of those statutory schemes, but I can tell you that as far as the Supreme Court standard is concerned, there is no year limit on anything. The judge, the court considers a series of factors
right
in determining whether or not speedy trial has been violated. Certainly, didn't this happen last year? The massacre, it happened last year?
Less than a year ago. It happened in November 2021. Never, ever would this be violative of someone's right to a speedy trial. That's what I thought.
Right. So things that would be considered by the court in determining whether or not the trial, it took too long to get to the trial, the Sixth Amendment is violated, and the case should be dismissed with prejudice, are things like multiple continuances by the prosecution, right? Continuances without good cause. The client is held. The client has not asked for any of the continuations. And then on top of that, the client has lost out on like evidence because of the passage of time. Like a witness dies or evidence spoils. There's no number that's set on it. You know, cases taking 3-4 years to get to trial have been found not to violate the constitutional right to a speedy trial.
That's what I figured. Yeah.
6-7 years, something like that, before your trial court, and then eventually the Supreme Court would say this person's right to a speedy trial has been violated. We have cases from 2019 that are still sitting on the docket here in the state of Maryland that the court has found good cause to continue the case for various reasons, and speedy trial is probably not going to be implicated in it.
Yeah, that's what I thought, especially considering, again, the incident itself happened in November. And so I think the Second Amendment amended complaint was filed in January of this year. So my thought was like the right to speedy trial for the amount of people killed and the amount of evidence that probably had to be collected. I don't think his right to a speedy trial has been violated here.
I would say that that is one of the fastest trials I've ever seen, especially for a 6-time homicide. So 6 people dead, that less than a year to get to trial. My double homicide case that I did earlier this year took 3 years to get to trial. And I'm not saying that the speedy trial wasn't violated because, you know, that's something that will be raised on appeal, but it's very unlikely that the appellate courts would consider that the speedy trial was violated. But it's a case-by-case analysis. Less time and more time can be found to be violative of speedy trial. Think about if someone's incarcerated and then the state doesn't do anything with the case. Like they don't do anything. They don't provide discovery. They just completely abrogate their duty. Then they ask for a continuance to get themselves together. The court gives it. They do the same thing at the next trial date. The person like loses out on things because of that. Then you're looking at a speedy trial. Not ever in this case would this man's case be overturned for a violation of it, or would the case be dismissed? Because the trial court can dismiss the case for a violation of a speedy trial right. But the trial court dismiss the case for a violation of his right to a speedy trial. I just could never see it.
Yeah, that's what I thought, because again, like I said, I agree with you that given what happened, the magnitude of the incident and the fact that we're in the middle of trial, I don't know where the hell he's getting this idea. And Ed, I know you mentioned that he wanted a continuance, but I would imagine that a continuance by the defendant wouldn't be counted in favor of a right to a speedy trial. If the defense wants a continuance, I don't think that would be that kind of time would be counted.
So I think we're on the same page. So if the defense asks for the continuance, and that's the reason the case hasn't gone to trial yet, the minute you ask for the continuance, they're going to be like, your speedy trial rights are not violated. You waived them because you wanted a continuance.
Right.
It's going to be nigh impossible to get a case dismissed for speedy trial violations once the defense asks for a continuance.
All right. Thank you. Thank all of you for the super chats. I'll get to you towards the latter half. Yeah. I'm sorry. What you want to say something, Natalie?
Oh no, I was saying, I forgot what I was saying, but I was making some like little correction to something I just said. It'll come back to me later.
All right. Yeah. I see that guy's in the chat. Thank you, Buxom Browncoat, for he says a timestamp I'm looking for is 30 to 35 minutes in. All right.
Awesome.
We're way past the speedy trial date. Way past. When the
that's great.
Change of venue motion was,
even though they tease me all the time.
I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That
90 days
denied
and that again, that could be like their statute.
I still don't understand how that was denied when it's
maybe
clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County.
Oh,
that's
the other thing. Yeah, now he's having an issue with the venue. A motion was raised to change venue, and it was denied way back.
I was about to say, because now you're in the midst of the trial, so I mean, a motion to change venue makes total sense, but it's way too late for that now. So okay, so it was denied. So at least it was raised, and it can be litigated on appeal. If he wins his appeal, it would be for something like that, because
I would have said that the only modicum of validity I got out of this entire endeavor was this issue of venue. That's basically it.
That is a really, really good issue, but that's not going to be decided now. The trial has already started.
We're already gone, yeah.
Yeah,
all right.
It's too late. Yeah.
All right, I'm starting at the 30-minute mark. Skipping ahead.
Why was I not provided with a certified copy of your oath of office?
Oath of office, drink.
Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked.
What?
You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified?
What?
You gave me a copy of your oath of office, but it's not certified. So how can I verify that is the true oath of office that you
shouldn't even have gotten that?
How can I verify that is?
I agree. That was a big mistake by the judge. She should not have entertained him even to that point.
Stated any legal reason why. I have the right to ask for that.
No, you don't. No.
Allie Fox, my bingo card just burst into flame.
This is my defense, which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people.
Judges?
I don't know.
That's not something that we physically keep. That's weird.
From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you not a public servant?
Public servant, drink.
This is making me depressed.
I know.
You also know.
I promise, as soon as we get to his treason drop, we'll skip to the responses by the prosecution and the judge.
Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name.
All caps,
Nor
drink.
has it ever been my name, nor
God.
have I ever seen
Kill
that name
me.
or individual. Every single filing or paperwork
I ordered
all in capital letters.
I ordered tacos just
Ever
to help
since
me
September 29th.
cope
roughly
with the
around
pain.
there. Now everything starts to go to lowercase letters. Why is that? What prompted the sudden change? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client.
Who's your client?
Set for value in return for value. We go through this every
Oh, I got the A for V. Drink.
You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present? You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case. Nowhere does it say you can create a 4th option. Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office. Treason.
There it is.
What did he cite to?
Treason.
18 USC. Hold on.
2381.
18 USC 2381.
18 USC 2381.
Not upholding my constitutional rights. I'm sure you know about.
Let me know when you got it.
USCS 2381.
Treason. Whoever owing allegiance to the United States levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death, or shall be in prison not less than 5 years and fined under this title, but not less than $10,000. Shall be incapable of holding any office under the United States.
Wow. Okay, so this clip actually doesn't have the response. All right, so I'm gonna go back to the live chat.
Accuse the judge in his trial of treason.
What's he gonna do? Run?
Here we go.
This is so.
All right, I found it. Hold on, let me share it for you guys. Capital felony treason. Whoever said that in the chat, you know, I know what you're referring to. Let me share.
That is so disturbing.
There we go. All right. Let me know if you guys can see it.
I just see watch stream.
Should have the prosecutor on there. If you click on my name, if you click on it, you should see it.
I click on
my name where it says
Natalie,
that says live.
Watch stream.
Wait, what?
Click on the words that say watch stream.
I did. Now I see it.
All right, perfect.
Mr. Brooks, I've given you about 50 minutes to make your various arguments.
Can't hear it.
You've now repeated yourself
Can't hear it?
I can now.
Oh, okay, good.
a number of times, so I'm going to turn to the state to see if they have any response.
No.
Go ahead.
Thank you, Judge.
Oh, Saifa, I know you want to see that, but I'm not gonna go to it. But in the middle of his, briefly in the middle of his rant, he talks about how he's been seeing on the internets that there are mean comments on YouTube talking about him.
Oh, please, come on, Artie. Come on. I've got 30 more minutes. Come on.
I don't even. What part? Saif DK, what part? You're gonna have to help me out here.
timestamps. Come on with it.
I don't want to go through the whole thing though.
He has a tablet. He has a tablet to do research, so you know he's probably searching his name. Hi, Mr. Brooks. Ask for an attorney.
Is it towards the? I think it is towards the end. Oh, I gotta share it with you guys. Hold on. There. Let me know if you see him back on again.
Was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. Be even a time where I'm not accessed, where I don't. Hate mail that comes from people right here. Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's still talk throughout the jail about it.
That's your fault.
There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial.
Okay.
Hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed. Yet and still, that was denied. It's impossible for impartial jury to be found in this county. And that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That would be accurate.
I think it's, again, this is probably the only
that this whole
close to valid argument he makes in this entire screed.
The reporting,
and actually, he's making an argument for why it's okay to raise it now.
There were Facebook groups created because
right.
The jury is getting tainted, and so he should get a change of venue. So this is actually
live stream
very
on Court TV has
here it is.
Comment sections.
Comment sections.
Where a lot of insensitive and nasty things are said.
Oh, welcome to the internet.
The sheer insensitivity of some of the things that are said on there.
Yeah.
I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, that I have children too.
Oh.
Family too, loved ones too. That also have been ridiculed.
All right. I'm not gonna let him go on with his own sob story. I'm not in the mood for it. But we're gonna go to the prosecution's response to his screed.
I genuinely feel sorry for.
I feel sorry for the kid. No, I feel sorry for the kids. I feel sorry for the kids who have to it would not surprise me if the kids probably got a lot of bullying, probably got a lot of hate. It's not surprising. My only semblance of empathy is towards his kids, not for him.
Yeah.
But
his domestic violence victim.
And obviously his ex. Yes.
Yeah. He's horrible. So.
All right. All right. I'm back to the other part where the prosecution is about to make their response.
Okay.
Go ahead.
Thank you, Judge. Judge, I'm going to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin,
Hansen.
federal case found at 2022 Westlaw 3045190.
It's an unreported
I'm
opinion.
so sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Citizen theories are frivolous and wholly without merit. The court goes on to cite to Bay, B-E-Y,
Yep.
versus the state of Indiana.
Bay versus Indiana.
7,
Hey.
Fed 3rd, 559, on pages 559 through 560, a 7th Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly,
You didn't call out that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting
Right.
the state.
They didn't object
as
you
they
when you
did
were
not
talking
interrupt you
bullshit.
for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks
Not yet, Smoke.
knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial.
Yup.
He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." And then he told this court, whatever it was, 2 weeks ago.
He did.
Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been
She's the lead
exceedingly
prosecutor,
patient,
people.
exceedingly respectful of his rights at every turn. At every turn.
I agree.
I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement.
Bullshit.
The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework.
I mean, I didn't
And
realize that. He's
simply
using
sitting
trial
here-
prep from the public defender's office.
Yeah. No. There was no doubt in my mind. Oh, there was no doubt in my mind that the public defender's office had about 80% of the work done and ready to go by the time he got it all.
Yeah. I was like, how did he prepared impeachment? How did he do that? He's using their notes and their impeachment and their everything they had prepped, and they gave him their prep work, and he's using that, and then he's tacking on sovereign citizen bullcrap at the end of it.
Yep.
Wow, that makes so much. Why did that never occur to me? So when you say, oh, you basically got the answers handed to you on how to take the test.
Oh yeah, he had a cheat sheet going in.
Oh, that's crazy. It's like an open book exam.
Mm-hmm.
Wow. Okay. All right. Oh, dang.
They're reading their notes, reading their cross-examination questions, and asking the questions and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial, and on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator.
Which they actually put her on the stand.
It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety so that other inmates do not inflict physical harm upon him.
Probably.
He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. I would also cite the court to U.S. Ex Rel. George versus Lane, L-A-N-E, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system, paralegal training, or law school education. The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit.
And he was
Much
rude about
of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting.
Oh, yeah.
I don't know who's giving him these materials.
He's got a script.
But he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Objection to that. Your Honor, that's a load of crap.
I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made.
Disrespectful.
Hold you up from which.
Not that I didn't accuse you of treason before, but that was just disrespectful.
That's a load of crap. For her to sit there,
Mr. Brooks,
for her to sit there.
Objection is noted.
For her to sit there, Your Honor.
No, it's my turn. Let me go through this. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility.
Yes.
I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point. Please listen, and please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. Then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise, and then pursuant to state law, the clerk of court chose names to strike by lot. Again, there's
I didn't know that.
On this record before the court to suggest that this jury that.
Well, my understanding is that he used a lot of well, there was like a 2-stage process. Well, based on what the judge said, there was a first stage where he did make a lot of challenges, preemptory challenges that they did grant, and then after that initial pool was diminished, there was an additional round of I guess review of voir dire, where the judge granted them an additional each side an additional 10 preemptory challenges that that he didn't exercise. So there's a first
that we have is anything but fair and impartial, and I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive, they come to this court as the case law says. There's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining or sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That is what circumscribes the rights that a defendant or the state has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous.
Good for you.
This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear.
Bam. Subject matter jurisdiction. Have a nice day.
Or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201, which requires that the basis for the relief being requested be stated with specificity and be based in law and fact. The vast majority of the points that you raise, sir, are issues that you can raise on appeal. It is true, you have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted the record is going to be very clear. All right, I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always do that.
Yes, I have it. I've sped up the.
You raise issues.
I sped it up, guys.
I have never been made aware that you would want to change your plea in this case, and that you're not aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction and as simply a statement made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercise that right of substitution.
Oh,
so to say that you have a right to seek
I missed that part.
at any time would be a misstatement of the law. And even if you think that should be exercised, or there is a valid claim for that, sir, it's not been raised in the proper way before this court. This trial will keep going. I still expect the basic rules of civility and decorum to be followed. That includes, sir, that when there is an objection to a question that you ask, that you wait for the state to indicate their objection and the basis for it. If I need additional information, I will ask for it. If I don't need additional information, I will rule on it. And I do expect that even if you disagree with that ruling, that you will abide by it and that you will move forward. Whether that's asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum, and that's you not interrupt, and then you follow the rules of procedure. As far as the other issues you raised concerning your right to assistance of counsel, the record before this court over the many days that that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is required by the Constitution of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law, both case law in the state of Wisconsin and case law from the 7th Circuit Court of Appeals, which not only guides this court, but this court must follow. I agree with the state and would draw your attention to the 2 cases that were cited. United States ex rel. George versus Lane, found at 718 F. 2nd 226, and Retzlaff versus Moran, found at 2022 Westlaw 3045190. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir. And this court need not address them further. Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time, so I'll instruct the clerk to bring the jury out.
Well done. Marty, I gotta get going.
Levine,
the
415.
reason why I wanted to, all right, I'm gonna move it. The reason why I wanted to speed it up is for this last part. This is at a moment where now the judge clearly has lost her patience.
Objection. Relevancy.
Oh, sustained.
Over a priest?
Everything
Yeah,
that you
priest.
testified today, is it truthful?
Objection. Hearsay.
Overruled. You may answer.
Yes.
Nothing further, thank you.
All right, Nathan, you may step down.
Again, this is at 1.25
I'd like to get
playback
through
speed.
one more witness, but I want to take a short comfort break for everyone, so I'll rise for the jury. Thank you.
Stop it, Mr. Brooks. I'm down.
Mr. Brooks, not now.
Not in front of the jury.
Now. The jury is in this courtroom, and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks.
telling them the truth.
Stop.
Oh,
Ooh.
I'm putting you on notice that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is why
prove it.
your questions
Prove it.
are being
Prove it.
Prove that it's
objected to,
frivolous. Prove
and
that it's
why
frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back in 5
prove it.
minutes. Thank you, everyone.
I don't agree to an estoppel. Can you prove?
wow.
Yeah.
I don't agree to a estoppel. He's letting it spill out in front of the jury.
Yeah.
Oh,
Yeah. That happened in front of the jury. So
every day he digs the hole deeper and deeper, and I am blown away. Artie!
Yeah.
Okay, well,
I know you gotta go. You gotta head out.
yeah,
Head
I
out.
gotta go. And Susie wants her fancy feast before I get started with Ian. But,
Of course.
I've got to cover all this stuff tomorrow. So anybody
Yeah.
who wants to send me these timestamps, and Artie, if you can come on, because I don't have court tomorrow, that would be great. I need a cup of coffee. I need some water. I need to feed myself.
Absolutely. I hear
I
you.
dropped your link, Natalie. Have a good night.
All right, good night, guys.
All right.
Thank you so
Take care,
much.
Nat. Thank you for dropping in. I appreciate it. Yeah. Yeah.
go. If the next witness goes relatively smoothly, would you consider letting us call the second one and maybe wrapping up by about 6 o'clock?
Yes.
Okay, thank you. If not, he can come back tomorrow, but he's been here twice already.
Nope, we'll keep going. I prepped the jury for that yesterday, so we're good. I'm gonna have the jury brought out. All right. Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes.
Your objection's noted. We're gonna make up for lost time from yesterday.
So can we adjust the subject matter jurisdiction?
No, we cannot.
No.
We're not gonna address that either. That's still not gonna be proven, right? It's frivolous stuff.
Fuck you. Oh my god.
That's gonna get pressed every time. So.
You hear that? I missed that underneath his fucking breath. That's gonna be pressed every time, though. The level of defiance is infuriating. In case you guys missed it, here he said this. If you didn't hear that underneath his breath, I'm gonna put it at regular speed.
Still not gonna be proven, right? It's frivolous stuff. That's gonna get pressed every time. So I've yet to prove subject matter jurisdiction, any jurisdiction at all, right?
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. They are.
All right, thank you, everyone. Please be seated. The state may call its next witness.
Not in front of the jury. If it's not in front of the jury, then she's okay. If she were to go off like that in front of the jury, then there would be an issue. Thank you, Dr. Strangelove. I'm gonna get through the super chats here in a bit, guys. Stay tuned.
All right, Mr. Hallmark, if you would please make your way to the witness stand, which is on my right, up one riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record, and then spell each.
Lucas Hallmark, Lukas Hallmark.
Hold on a second. It would really help if our audio's on. I'm just going to have you do that again. If you would please state your first and last names for the record.
Lucas,
and then spell, sorry.
Lucas Hallmark, Lukas Hallmark.
Thank you. Go ahead, your witness.
Thank you, sir. How are you employed?
City of Waukesha Police Department.
What's your position?
I'm a detective
How long have you been with the City of Waukesha Police Department?
for approximately 15 years.
Has that been the entire time you've been in law enforcement?
Yes, ma'am.
Direct your attention to November 21st of 2021. Were you at the City of Waukesha Christmas Parade?
I was.
Were you there as a law enforcement officer, a spectator, or participant?
I was there as a participant.
And what group were you with?
I was with the Catholic Communities of Waukesha.
Who were you there with? I mean, other than the Catholic communities, were you with your family?
I was.
And generally, I don't need names, but was your wife present?
My wife and my 4 kids at the time, yes.
And what are the ages of your kids?
At that time, they were 3, 5, 7, and 9.
And approximately how many people were walking with the Catholic communities of Waukesha?
I believe there was about 45 or 46 individuals that were walking with us.
Okay. I'm going to show you a photograph and just ask you if you recognize it. It's Exhibit 121.
As a reminder, the monitors in the jury box have about a 20-second delay, so we need to be mindful of that as we show exhibits to them. They do come on the screen, I think, a little bit more quickly, but there's rapid succession previously, so.
And I'd ask that also be published to the jury at this time. This exhibit has previously been admitted into evidence.
Permission granted. And when isn't the jury, let me know when that exhibit comes up on the monitors in front of you.
All you guys watching, I appreciate it. Please, by all means, hit that like button if you can. It really helps the channel.
Yes, that was taken at Main Street and I believe East Avenue.
What day was it taken?
That was taken on November 21st, 2021.
And there are boxes with names that are associated with people through a red arrow. Do you see that?
Yes.
Overruled, he may answer.
Was that a yes?
Yes.
Okay. And as you review those names and the people that those names are associated with,
I have no idea, Deacon.
is that exhibit accurate?
Objection, leading the witness.
I would assume
Sustained in the
so.
form of the question.
Sir, do you know the people whose names appear on exhibit 121?
Objection, leading the witness.
Overruled, you may answer.
Yes.
And the arrows, do you see arrows on that exhibit?
Yes.
And they're going from a person to a name. Do you see that?
Objection, leading the witness.
Overruled, the exhibit's previously been received. He may answer.
Yes.
To clarify, Jason Peckloff, do you see him in this picture?
I do.
Can you, there's a touchscreen in front of you. If you can just circle where he's at in this picture. How about Camila Perez Gonzalez? If you can circle her. Maria Alvarez Dominguez.
Oh, here.
Lopez Revelar.
I apologize. I think Danny. I think I found it. This is a Reconstruction expert, and there's a clip here that apparently is at least a little bit of a bit of levity here.
As a Reconstructionist with the State Patrol.
Well, since about probably 2004, I would say till now, I average probably over 100 a year that I respond to. And these are serious crashes. They're not just, somebody driving into a mailbox. This is a criminal or possibly injury case involving criminal charges that we respond to. But probably on average over 100 a year for the last, since 2004.
Did you conduct a crash reconstruction analysis in downtown Waukesha from an event that took place on November 21st, 2021?
I did.
When did you begin your work on that analysis?
I worked with detectives from the City of Waukesha Police Department. On January 30th of this year, we actually went out to the scene to conduct a time distance analysis.
Where did you go at the scene?
We went to the Curry Insurance Company, which was the cameras that we decided to use after viewing all the videos. That was the best, as far as what I'm concerned, to use in a time distance analysis. It was the clearest. It provided certain things that made it necessary for me to do an accurate time distance analysis.
What are some of those certain things you referenced?
What we look for and what we've been trained to do is, first of all, we look for a stationary camera, one that doesn't move. So when we are viewing the video of the incident and we are, again, recording new video with the time distance analysis, that camera is in the same exact spot. That's the first thing we do. Secondly, we want to have at least 2 fixed reference points to actually see where a vehicle in this case is entering the first reference point and where it hits the second reference point. So those need to be really clear for us to get an accurate distance. And from that point, then we want to actually time or make sure the timing on the video
Isaac
software
Newton
is
has
accurate.
joined the chat.
And that's simply a stopwatch that we use
I can't wait.
to verify that that video is timing correctly, not too fast, not too slow. So once we have all that done and we determine those 2 points, we'll bring a vehicle in, and in this case, an exemplar vehicle that matched the description, I think your make and model of the vehicle that was in the parade. We actually will have someone, me in this case, inside, watching the video on the screen, seeing when that exemplar vehicle comes into the screen. When it comes into the screen where the vehicle did at the time, we have somebody mark that location out on the roadway. We then do that for a second point further down. In this case, we had 2 points. Once we have those 2 points established, then we're bringing our survey equipment out, which is a Trimble unit that you've all seen them out on the roadways and then people's homes where they're surveying. That's what we use. Very accurate instrument. Just to give you an idea of accuracy, at about 300 feet, it's plus or minus 1/8 of an inch off. So very, very accurate unit, which we use all the time for crash reconstruction. So once we have that distance, we verified the timing. It's a pretty simple calculation that we do to determine a vehicle's average speed through that particular distance that we have. And just keep in mind it's an average speed, so it could be moving faster or slower during certain portions of the distance, but it's just basically taking that average speed through that distance that we measured.
When you used that Trimble machine to conduct your measurements, did you use those measurements to later produce a 2-scale scene diagram?
I did.
Okay, I'd like to project for the witness only exhibit number 56, please.
56?
Yes, please.
Thank you. Go ahead, Jill the witness.
Do you recognize the diagram on the screen in front of you?
I do.
What is it?
That is the scale diagram that I created as a result of the Trimble measurements that I took out at the scene.
Remove exhibit 56 into evidence and request permission to publish.
I can't see it on my screen.
He's right.
Oh, I don't know why. We'll need to check the cabling. I can see it on mine.
What do you say it was at?
56.
I don't know. We can.
Can you get Zach down here,
please. Check the. Oh. Let me know when it's on the screen in front of you, sir. All right, continue then. Oh, and Exhibit 56. Well, first of all, let me review it. It's been offered by the state. You've now had an opportunity to review it, sir.
Hey, put it. She's talking to you, man.
Exhibit 56 is received, permission to publish is granted. Go ahead.
Dumbass.
Okay, could you please walk us through what we're looking at here?
Yes, again, so this would be a diagram, two-dimensional orthogonal, so basically looking from the top down at the area that I did measure at the time we did the speed analysis. Obviously, it depicts a vehicle at a starting point and a vehicle at an end point. The vehicle at point A represents where that vehicle came into that east camera. It was located at the Curry Insurance Company. And as soon as basically...
Yeah, I heard the trial ended on a high note. We'll get back to it when we can.
The representative was there.
And that's where I'll probably end the stream.
We marked that location on the roadway.
Because my food's here.
We continued down to the secondary point, which I determined was the crosswalk. And we marked at that point once the exemplar vehicle reached that. And that's how we got that distance of 141 feet, roughly 3 inches.
Okay. And what do you do with that distance once you have that measurement?
So once we have that measurement, that's one part of the equation that we need. The equation that we need, just really explain it briefly, comes from Newton's laws of motion. Force equals mass times acceleration. It's part of Newton's second law. The formula that we use is velocity equals distance divided by time, and then we convert that velocity to speed. So we need two inputs in order to calculate the average speed of that vehicle over that distance. The first, obviously, is distance. The second is time. Now, how we get the time is we take the actual video from the incident, and we have a stopwatch, and we time it when it reaches those fixed points. And we do about 20 iterations, and we average those 20 iterations out to get a time. And that's the second part of the equation that we need in order to get that velocity or speed. Once we have that time, in this case it was 2.7 seconds, we round up and increase that time to the nearest whole number, which was 3.
Why do you round up? I'm sorry to interrupt you there.
That's fine. We round up always to give the benefit to the vehicle, because obviously the longer it takes to travel that distance, the slower the speed will be. So we always round up to the next number. If it was 2 seconds, we'd round up to 2.5. So it's about every half-second interval that we round up to. So now that we have the distance of 142 feet roughly and the time of 3 seconds, not 2.7, we came up with the speed of the vehicle, or average speed of the vehicle during that segment of 32 miles an hour.
32 miles an hour as an average speed from point A to point B as they're depicted on this diagram?
Correct.
Sustained as to the form of the question. Please rephrase. The jury will disregard the last answer.
Could you please explain for us, again, summarizing what average speed you calculated and over what distance?
Yes. So the average speed, very simple. We marked point A, we marked point B, we had that distance, we had that time. The vehicle speed between point A, or the average vehicle speed, let me reiterate, was 32 miles an hour between point A.
The purpose of using...
Just for court purposes, I think it's...
You used a 2010 red...
Okay.
3,368 pounds.
Okay, I'm moving straight to the cross-examination.
Results and diagrams.
Here we go.
You said normally you don't put...
Okay. That's all I have for this witness. Thank you.
Thank you. Cross.
Yes. This is kind of distraction still being on here. From your testimony, it seems like you've been doing crash reconstructions from quite some time. Is that fair to say?
Yes, sir.
Around 2004, I believe you said?
I was in the program from about 2002, but really started getting into full recons about 2004. You need a little bit of training first before you can actually go out and be on your own.
You stated that you worked with detectives in the process. Do you recall who that was?
Yeah, that was Detective Casey.
On getting the calculation of the speed, did you work with anyone on that side of your investigation?
No.
So it's pretty much just you and the detectives?
The detective did not assist me with the speed calculation. He just assisted me with obtaining the videos and also assisted me, excuse me, out at the scene where we did the testing.
I think the exhibit showed the building that had the camera. Do you recall which streets that were along the parade route?
Yeah, that was in front of Curry Insurance on Main Street.
And the point A and point B, did those start from a cross street, or was it just the main?
The insurance company has cameras outside by the sidewalk. There's 2 of them. There's one towards the east and one towards the west, right at the front of the building.
You made reference to the distance traveled in feet.
Correct.
I think it was 141?
Correct. 141 feet 2 inches, a little bit over that.
And you made reference to the average speed. Any reason why the average speed wasn't depicted in the exhibit?
That's just a calculation that we do that's included in the report. I don't normally do that in the diagram.
So it would be fair to say that you created the diagram?
I did create the diagram, yes.
You said normally you don't put the speed calculation in the diagram. Would there be any reason for that?
It's in the report. It's not necessary to put it in the diagram.
Have you ever done that before?
Could you rephrase the question?
Have you ever not included the speed analysis in any crash reconstructions that you've done before this one?
Not a diagram.
Referring to the diagram, or are you referring to the report?
Referring to the diagram.
No, I do not put speed calculation results in diagrams.
On any of them?
On any of them.
Did you create any diagram with the speed calculations present on it?
No, I don't. The diagram that I created is the one that was up on the screen.
And then from there, you put the speed calculations just in the report?
Yeah, I normally just put them in the report, yes. I don't have any recollection of putting one in the diagram.
Would it be fair to say that it may be a little bit difficult to locate what you analyze for speed if it's not in the diagram?
No.
So if you wanted to know the calculation of the speed, you would have to read the report.
Correct.
Yeah.
Would it be fair to say that it might be easier to find if it was included in the diagram?
My diagram is included with my report, and that's all one unit, so it is in the report.
Thank you, Kraken.
Can you explain what the S6 is?
Yes, the S6 is the name of the Trimble robotic total station that we use to actually measure things at crash scenes.
So that's like a certain technology or something, would that be fair to say?
It's a piece of surveying equipment that if you've been on the road, you've seen them where they're measuring the roadways, or if somebody's building a home. Same type of equipment, we just use it for crash reconstruction.
And what is a prism? Is that in direct relation to the electronic distance measuring system?
Correct. The total station is one part of the equipment that we use. The prism is the other. The total station communicates with the prism through an electronic digital measuring system, which is a laser. The two pieces are needed, in this case, to collect the measurements that I collected. Not a necessary component to using the equipment, but we normally do use the prism when taking measurements.
And that prism's pretty accurate, you would say?
Well, the unit is accurate.
What about the prism?
Yeah, it's all accurate. The unit itself is very accurate. At 300 feet, it's about 1/8 of an inch either way, plus or minus.
And is the CAD the diagram that you created?
Could you rephrase the question, please?
Is the CAD, is that software related to the diagram that you created?
It is.
In what way?
The computer-aided design software program that we use is a tool that when we transfer the measurements from the Trimble total station, we transfer that into the computer-aided design program, and that's how we create our diagram.
I mean, I have no background whatsoever when it comes to surveying reconstruction. But even I feel like I can surmise what he just said there is that that's a tool that allows them to accurately put a 2-scale diagram on paper from the data they collect.
can you explain what the 2.4 gigahertz radio technology is?
That's just software that's built into the total station, the Trimble unit, as part of its communication.
And is that communication radio?
Yeah, there's a radio inside the unit, correct.
Well, 2.4 gigahertz.
You made reference to something called Newton's law. Can you explain a little bit further what that is?
Newton's laws of motion are what we use as a big step in our Reconstruction field. A lot of formulas are derived from Newton's laws, including the formula that we use to calculate the vehicle's average speed. Sir Isaac Newton obviously invented the laws of motion. We all learned that in high school, and that's part of the process that came with the formula that I use to calculate the average speed.
I always thought of Newton as gravity, so that.
Oh my fucking god!
Bit of new information.
Oh god, you fucking idiot!
You made reference to part of the crash reconstruction was finding a similar vehicle. Would that be fair to say?
Yes.
And you were able to find a similar vehicle pretty easily, you would say?
That would have been the City of Waukesha Police Department which found the vehicle.
And you made reference to it being in the parade as well? Or part of the parade as well?
The exemplar vehicle?
Yes, the vehicle that was similar.
The exemplar vehicle was not in the parade.
I may have misinterpreted what you were saying. And you said it was found by the Waukesha Police Department?
Yes, sir.
Do you recall if that part of your investigation and the creating of the graph and all that technology that goes with that, was that part of the same day, or were they done on at different times?
I'm sorry, are you referencing the diagram, the creation of the diagram?
Right.
No, that was
because
not.
It seems like a lot of technology went into getting the diagram created and different variations of that, and then also using a similar vehicle to, I guess, simulate would that be fair to say, simulate the incident?
We use the exemplar vehicle for our testing.
Was that done all the same day, or was it done?
Sorry, could you rephrase the question again? I'm not understanding what you're asking.
Was the creation of the diagram and the simulation of the vehicle done on the same day?
No, it was not.
So it'd be fair to say it was a process involved in getting all the information?
Correct.
And you stated that was done around January 30th, around that time?
The testing was done on January 30th.
And what about the simulation from the similar vehicle?
I'm sorry, could you rephrase the question?
Do you recall what date the simulation was performed?
Are you asking when I completed my analysis?
Specifically the part of the similar vehicle being used.
That was January 30th. We did the testing out on Main Street in front of Curry Insurance.
So what part of the process was done at a later date?
The diagram, the calculations, the time distance analysis.
Investigation?
Are you referring to when I completed my reports?
Yes.
No, I don't know what day that was.
Was it sometime after the January 30th date?
Correct.
Would you say there was a delay in finishing it, or did something cause you to kind of, let me rephrase that. Was there anything that may have delayed you finishing the investigation quickly?
Can you rephrase? What do you mean by quickly?
By it seems like there was two parts of it: getting the simulation done and then the actual diagram and things of that. Any reason why that couldn't be done closer together?
Well, first of all, it's not a simulation because a simulation is different than what we did. This was just some testing we did out at the scene. Secondly, as I mentioned earlier, I respond to hundreds of crashes. It depends on what I'm working on at the time. Once our reports are completed, they need to be peer reviewed. All that process takes time. So there's nothing that delayed my report. If you want to use me going to another crash, that possibly could have delayed it, but no delays that would affect the outcome of the report or the accuracy of the report.
No, I wasn't going to that part of it. I was just kind of curious to what may have spaced out the dates. That's what I was really getting at.
We do a lot of reports every year, and obviously we're not just doing one report a year. So every report is different. Every report requires different types of analysis. So there's really no set time on when we can finish a report compared to when we started. It just depends on what else is going on outside of our time in the office.
No further questions.
Any redirect?
No, thank you, Your Honor.
All right, thank you, sir. You may step down.
Thank you, Your Honor.
You may. State may call its next witness.
Is going to call Dr. A.B. Shield.
This is the first medical examiner.
Cross-exam.
I won't show I won't show, but she does this is the medical examiner who did the autopsy for the child who passed away. And it turns out that the child or the parents elected to have him be an organ donor. So that was what the parents decided. And this is the immediate beginning of Cross, where he stands there and gives the impression that this is taking a toll on him. Given everything that's actually transpired, especially beforehand when he was doing his whole before when she gave him the 50 minutes of sovereignty to this creed, I'm not buying it. I'm not buying it at all.
One second.
By the way, this is sped up too. I skipped the direct, because it's pretty rough. It's pretty rough. I just wanted to highlight this guy's attempt at conveying feelings and emotion. and I wonder whether or not the jury's buying it. My gut is telling me no.
Mr. Brooks? Your cross, please. Do you have any questions for this witness?
Just 1 second. I apologize to the court for taking so long. Do you know why the decision was made to why the decision was made for Jackson to become an organ donor?
Objection is irrelevant.
Relevant. No relevance whatsoever. I don't even know why the fuck he started out with that, but
did you did you end up doing any more autopsies besides those 3?
I'm not. I'm gonna move on, and I'm gonna go with the very end of the trial.
Permission to publish is granted.
Yeah.
Actually, do you recognize this person? Ted in Exhibit 162, but is the same, is that the same type of hat in terms of, has the same wording on it, same color, same palm color as the hat that Eileen was wearing in Exhibit 162?
Objection, hearsay.
Overruled. You may answer.
It looks remarkably close, same color, same patterns of the lines, the writing, and then with the top on it. Yes.
Thank you. I have nothing else.
All right, your cross, sir.
So you saw all those videos that were shown, all exhibits rather, all 12, 13 of them. You saw all those before today?
I don't recall there was 12 videos, to the best of my knowledge.
126, 15, 137, 136, 135, 140, 158, 160, 154, 162, 92, at least 11 or 12.
Mr. Brooks, I'm going to strike your comment because you cannot testify. You did not let him answer. Let him answer first, and then you can ask follow-up. The jury will disregard the statement made by Mr. Brooks. Go ahead.
I believe there was only 3 or 4 videos, but there was numerous screenshots or photos taken from those videos.
That's why I said exhibits. Have you seen all exhibits before today?
I had seen those exhibits, yes.
And do you know who took any of those exhibits, the videos or still shots?
No, sir.
So how were you able to see them?
Can you rephrase the question, please?
How were you able to see them if you don't know who took them?
I saw them on the screen. I'm not sure I'm following your question.
Before today, you said you saw them before today. That's what you just said. So I'm asking, I asked after that, do you know who took them? You said no. So how could you I guess I'm asking, how would you know? If you don't know who took these videos, how were you able to see them before today?
I believe they were collected by the police department as evidence.
And that's how you saw them?
That's how we were able to view them afterwards, yes.
Do you know when you viewed them?
I don't recall.
Did you view all 12 of them in their entirety at the same time, or were they at different dates?
Yeah, back to the form of the question.
Grounds.
Did you view them all in their entirety? Again, it makes it seem like he's referring to videos, and if he is, that's fine. If he could just clarify videos or exhibits.
Sustained as to the form of the question, please rephrase.
Exhibits.
Can you just repeat the question, please?
At what time did you see all the exhibits in their entirety? Was it the same day, or was it different days?
I don't recall specifically. I just reviewed the exhibits, the photos, not the videos, but the photos, as you're explaining in these exhibits, prior, just in preparation of my testimony.
In preparation of your testimony? What do you mean by in preparation of?
Preparing my testimony for court, making sure that everything maybe kind of recalling my memory, anything to that nature, making sure that everything is accurate in what I'm going to testify to.
If everything you're going to testify to is truthful, why would you need to prepare for it?
Objection.
Grounds.
Sustained as to the form of the question.
Argumentative.
Why would you need testimony preparation?
This is a pretty significant incident. I wanted to make sure that I was prepared fully for being here and testifying.
Wouldn't it be easy to just come in and recount what you saw?
Objection. Argumentative.
Grounds.
Argumentative.
Sustained. Please rephrase.
Is it fair to say that it would be fairly easy to state what you saw that evening?
Yes.
So why exactly did you feel the need that you had to prep yourself?
Objection. Argumentative.
Grounds.
Argumentative.
Sustained, also asked and answered.
I'm going to direct your attention to Exhibit 154, which is a video. So that's clear for the record, not a still frame. It's a video.
You want to put up for him?
I want to put up for him.
All right, it's been received before. Put it up, please.
Can we go to 41 seconds?
Sure. Thank you to the state for assisting. 41 seconds, you said?
41 seconds. Is it fair to
Hold
say
on,
that?
do you want to wait until the jury has it in front of them?
Yeah.
Okay.
Sorry.
It's okay, there's a delay. Sometimes it's long, sometimes it's short. Seems to be long right now. All right, we're good. Go ahead.
So in this exhibit, which is a video that's paused at 41 seconds, we can see two people laying on the ground. Would that be fair to say?
Yes.
Can you see any of the two people's faces right now as it's paused?
No.
So it would be fair to say that you can't positively say who that is from this part of the video that's paused right now?
Well, based on my experience, based on clothing descriptions, obviously Idea and Marisol are mother and child, and body structures, that's how I'm able to identify who they are.
What do you mean by body structure?
Well, Idea is a little bit smaller and Marisol's is a little bit larger, and that's how I have memory of who she is.
Would you agree that they're kind of like bunched up, like kind of balled up?
I would agree that Idea is, yes.
Can you see faces?
No, sir.
So it would be fair to say that you don't know for sure who that is?
I'm pretty confident that's Marisol and Idea.
Pretty confident?
I'm very confident.
So why not be very confident the first time?
Oh my God.
Grounds.
Sustained.
Let's go to 58 seconds and pause. Right here in front of us, we see three people kneel down. We see someone with a pinkish blanket.
Ah! Hold on. I actually just want to see the tail end of the the stream, and that's where we're gonna close out. Am I blind? Where is it? Do they not have it? Hang on. Here we go.
You heard.
So it'd be fair to say that you're not sure who that is. And what happened with the...
This is pretty
Wow.
inane testimony.
Sustained as to the form of the question, please rephrase.
In the summary that was given by the officer that you gave the report to, so it would be fair to say you knew that they were hurt, but you didn't know the severity of it.
Exactly.
Is that a yes?
Yes, sir.
Thank you, sir. You may step down.
All right. Here we go.
Much for your patience, as it was the court who wanted to keep moving a little bit tonight. I know we're a little bit late. I will read the instruction, and then you will be dismissed for today, and we'll see you tomorrow morning. Do not begin your deliberations and discussion of the case until all the evidence is presented, and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties' lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties' lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. All rise for the jury, please.
fuck is that? That look he's given. Jesus.
I just have a couple of housekeeping matters. Please be seated. My recollection, there's been a couple of exhibits that were annotated and captured that I don't know were specifically moved in. I'd ask the parties to look at that and let me know if there's any requests as it relates to that. I also want to provide the parties with a copy of an incident report. This relates to an incident last week from the 6th where I told the parties, or I asked the Sheriff's Department to provide me with a report regarding the incident with Mr. Brooks and being removed from the courtroom, and I believe he may have even filed like a use of force form or something like that, but I wanted to have it notated or noted in the record, and so that incident report has been filed with me. I have a redacted report so that the Sheriff's Department is in compliance with that. The parties are getting an unredacted report. The unredacted will be kept on file, but sealed, and then the unredacted will be and the redacted will be what's available for the public, should anyone request that. So that's one thing that's coming.
Yeah, he filed it. I think he filed a UFR, a use of force report.
Then, just as a courtesy, even though I'm not required to do this, sir, I did follow up on your inmate communication form with our clerk of court, Monica Paz. She has, I have the response here, and I'm going to provide that for you so that it's notated on the record. And so there's a cover letter, and then there's some documents pursuant to your request. I'll give that to, and then along with, on the back will be that incident report. So that's being provided as well. And then the state, you'll get a copy of that incident report. I don't know if you want a copy of what Mr. Brooks was requesting, but at least that inmate communication form has been filed into the case. I believe it's documents the state could simply pull off of the electronic filing system in any event. And then lastly, I had marked, this is the exhibit 6 that I previously had ordered struck. I just wanted to make a record that it's marked, it's in this envelope, it will be kept with the file for any potential use later on. I just hadn't made a record of that, so that's there as well. That does cover all of my housekeeping issues. With that, given the state's request or Attorney Opper's request to start late tomorrow, and frankly, given the late night tonight, we will start tomorrow at 9 a.m. Was that enough time for you?
Yeah, yes. I was actually going to withdraw my request because we have another jam tomorrow in that we have a witness that we have to guarantee to get out of here by noon. So my request is perhaps, if the court's willing, we could start at 8:30 with the preliminary matters. We could still have the jury come in at 9, but if there's any preliminary matters, we could start with Attorney
I need to let
Basie.
them know. I told them 9:15 in my note that I gave to Mike, so I don't know if we can still get a hold of them. We probably can.
Okay.
So if maybe one of someone's going to need to tell them quickly. So I need to stay here so I won't step off. So we can keep going. But so 9 o'clock it is.
Okay.
You want to start? How about we do 8:45?
Have the jury here at 8:45?
No, parties here at 8:45.
Parties here at 8:45 without
jury
me.
by 9.
Attorney Basie and Attorney Witch will be here at 8:45. I'll be here at 9.
All right.
Okay, thank you.
All right. All right. Then, just Mr. Brooks, those things were provided to you?
Yeah, assess value, return for value these filings, and just very briefly so we can get out of here. I have to
Except for value, return for value.
What issue is
my
this?
understanding, how can someone who's not an injured party testify on behalf of somebody who is an injured party?
Jesus H. Christ.
I'm not addressing this. It is a frivolous argument. You have a misunderstanding of the law. We are in recess. I am leaving the bench. Thank you, everyone.
So that's a tactic agreement. We're not.
I appreciate that. Oh, finally. That's great. I appreciate that. And I hope that that's what's going to happen going forward. That the moment he raises anything Sovsit related, he's gonna cut it off immediately and either move on to the next witness or go to recess. Not even give him the fucking time of day. I hope that's going to be the norm going forward. Yeah, yeah. And he keeps saying tack it instead of tacit. But he's been saying that for the last couple of days. Moron. All right, let's go through the super chats and then close out. Because I want to get out of these work clothes. It's been a fairly long day. So starting out with Lizzie from Aussie, 1985 super chat. Already have a question for you. The judge knows a victim, or there is a conflict. Why is it not enough to change judges? Is it still? Yes. There are probably some circumstances where there is where a judge is required to recuse themselves, and then there are other ways where it's still up to the judge's discretion, and she's elected to continue on. I don't know if that's actually true, that she's related to a victim or she knows a victim or something like that, but I believe that's not sufficient in and of itself for her to recuse herself. But it could be something to raise on appeal. Kit, $192. Artie's the only one not petting a cat. Heresy, I know. I had fed them. Oh, hello, Archer. You want food? No, he does. But he doesn't want to cuddle. Robbie Anderson, $9.99. A beer for your troubles. Thank you very much, Robbie. I needed it. Mr. Shucklers, thank you for the $2. Edwin Wickham, thank you for the $1.99. He learned the treason defense on InfoWars, more than likely. Ghost Ryan, $5.57. Have a pint on me. I definitely will. Thank you. Arian Rod, $5. Everyone would have alcohol poisoning drinking while listening to him. True. That's why I elected not to actually play bingo. I care about the safety and well-being of my audience. Taco, $2. If the venue moves to a death penalty state, could he get the death penalty? No. If they grant the change of venue, it'd be a change of venue to some other county in the state of Wisconsin. They could not change the venue to an entirely separate state. It would be another county. Unpaid troll, 1341. Thank you very much, unpaid troll. Pronon 1990, $4.99. Thanks, Artie, for the video. Today was a hard day. It's the anniversary of my brother's death 16 years ago. Love you, Artie. Hey, I'm sorry to hear that, Pronon 1990. You have my sympathies, man. So I'm sorry to hear that. But thank you very much for your support. DR Strangelove, $10 super chat. At this point, Brooks' only move is to run the trial into a ditch and get a mistrial. His antics are only going to get worse from here on out. I kind of agree that he and that's what I predicted, that he's only going to get more desperate and frantic and probably try to get a mistrial going for him. That's all he really has left. Cracking me up, $10. Grounds. Thank you very much, cracking me up. Thank you to all of you who re-upped your memberships. As always, it's appreciated. And thank you, Poetic Justice, for the $2 donation. Much appreciated, man. But thank you very much, everybody. Hope you have a good evening. I'll be back on Thursday. This trial, because this guy decided to go full fucking sovereign citizen, has completely thrown off my Halloween October spooky streams schedule that I was really wanting to have. I want to play more Phasmophobia. I want to play more Walking Dead. I mean, we'll get around to it, of course, but well, I guess we'll have to save it for Friday or tomorrow evening. I think tomorrow evening we're probably
asked you to come on with her tomorrow night.
Oh, that's right. She did ask me to come on tomorrow night. Well, depending on what time that is, hopefully, and then hopefully I'll have some time for Phasmophobia afterwards, and then we'll probably have some more game streams tomorrow over the weekend, because God knows I need a break from this madness. But thank you guys again. As always, I appreciate it. And go check out, I guess Blue Bacon is live right now, so go check him out. See what he's up to. Tell him I said hi. I need to go change out of these clothes. So thanks, guys, again, as always. and I hope you have a good rest of your evening. Take care.